Welcome to the Whoa podcast about horses and horsemanship. I'm John Hare, and you found the place where we talk horses. This morning, I have on the phone a legal expert, an attorney in fact, Johanna Sheehe, and we're going to talk about equine legal issues and how you can protect yourself and your horse in this crazy world we live in today. Good morning, Johanna. How are you?
Good morning. I'm doing well. Thank you for having me.
Where are you located, Johanna?
I am in sunny Miami, Florida.
Oh, great. I'm in sunny California. In April here, it's going to be a beautiful day. How's it in Miami?
You know, I have to say we are having a beautiful day as well. The humidity has not yet set in. Any day now, I think we're going to be inundated with that tropical humidity. But today it's a lovely morning, I'll say.
Before I get into the legal talk, tell me a little bit about your background with horses, if you don't mind.
Absolutely. I've been around horses really all of my life. I guess I started taking riding lessons when I was about 5 or 6 years old. My father's best friend, and actually my sister's godfather, he and his wife had a large Arabian farm down in Miami. They've since relocated to Ocala, but I grew up kind of going to the farm and being around the horses, and that led to riding lessons, which led to showing, which led to a lifetime passion of mine for horses. My riding experience is in the English discipline, and
Mm-hmm.
my experience primarily is with Arabians and half Arabians, national show horses. I will tell you that I'm learning to jump. So I'm kind of getting exposure to the hunter jumper world, which has been a really fun thing. It's neat to learn new skills and be exposed to different disciplines, and that's one of the things I've really enjoyed about my equine law practice is that I have the opportunity to learn about all these different disciplines in the equine world. For example, I have a client who breeds and sells Andalusians. And I've learned so much about the Andalusian breed and the import process and, the process they go through for what they call revision for stallions to make sure that they're of a certain quality and so on and so forth. And it's really fun. One of the things I love about being a lawyer is that you're constantly learning.
Yes, yeah, it's a lifelong thing. And that's kind of why I wanted to talk to you this morning. In the horse world, the prices of horses have just gone up, and particularly in the Western. I think in the English and dressage areas, they've always been kind of up there. But it's more important now than ever, I think, to protect yourself. And what kind of problems do you see in your law practice dealing with horses?
Like anything, the problems can range. I deal with breach of contract issues, questions of premises liability, unpaid rent or board, things of that
Mhm.
nature. But, I think one of the biggest things that I see has to do with handshake agreements. I think it's very common in the equine industry for horse sales, breeding agreements, sometimes even leases or training agreements just to be done with a handshake, an oral
Right.
agreement, which I think is very customary. And nine
Mhm.
times out of 10, there's no issue. The problem, though, comes, of course, when there is a problem. One person's expectation is not in line with the other's expectation. Memories fade, memories change, circumstance changes, and there's nothing in writing to memorialize what that agreement was and to articulate each side's rights. And so when a problem or conflict does arise, when there's nothing in writing, it leads to trouble down the road.
Right. So someone might enter a training agreement and they think the trainer's going to do a certain thing. Months go by and maybe the horse doesn't respond as well as the trainer expected and the owner, and then they go back and they said, well, you were going to do this, or I thought you were going to do that. How come you're not training my horse, or things like that? How do you structure that in a contract? I mean, can you just write up a piece of paper, or do you actually have to involve a lawyer? What would you recommend a horse owner do who's trying to engage a trainer?
Sure. So I think that the short answer to your question is that no, a lawyer does not always have to be involved. Of course, I do recommend that when you're drawing up contracts, particularly if you're going to have kind of a form contract that you're going to use with a number of customers, that you have a lawyer review it just to ensure that it complies with all of your local laws, local statutes, and things of that nature. But at the end of the day, lawyers can be costly. And so sometimes that's not something that is necessarily feasible. There are actually a lot of resources online. There are the National Agricultural Law Center actually has a compilation of state laws regarding the equine industry that you can consult. And there's a lot of form documents online. Now, I don't necessarily recommend that you just pick a form off the internet and use it, but they certainly can provide some ideas in terms of the things that you might need to articulate. I think in terms of like a boarding agreement and a boarding and training contract, it's very important that you are articulating specifically the services that are going to be provided. If it's a full board and training, what does that mean? If it's half board, what does that mean? What are the
Right.
expectations? What will happen in the event of liability? What are the terms of termination? Is there a notice requirement? Things of that nature. It's always a good idea to kind of think about the relationship as a whole and how you foresee it playing out down the line. So, one of the things as lawyers we try to do is we try to, look around the bends of the curve to see, okay, where might a problem arise? But, in broad strokes, I think it's very important that there's clarity in terms of what's going to be charged, when it's going to be charged, what service is going to be provided. Are there any guarantees? Are there any limitations? Just to make sure everyone's on the same page.
Right. And so then that way you have fewer disputes. I think if you're a trainer and you have some sort of contract like agreement where you've delineated the services you're going to provide, I do think you come off more professional if you do that instead of just a handshake. But
Hmm.
for hundreds of years in the horse industry, especially in the West, everything, like you said, was done on a handshake. I think we might have been in a little bit different culture back then too, so I'm not sure if that applies. And then when you were talking about the boarding stable scenario, it almost sounded like you were talking about if you were the stable, how to protect yourself. Are there things that the boarder can do to make sure that everything's okay for their horse that's going to be staying there?
Sure. I think it's just as important for the boarder to review these contracts and to have input as the stable. I think if you're a boarder, again, you want to make sure that you understand what you're going to be charged and what that monthly, if it's a monthly board, is going to get you, exactly what the expectations are in terms of feeding schedule, stall cleaning, turnout, so on and so forth, to provide for the care for your horse. Another very important thing to ensure if you're a boarder is that there is set forth in the contract, or if you don't have a contract, at least between you and the boarding facility, is what to do in emergency. As much as we want to be available, and I think so many of us are, have our phones with us all the time,
Right.
sometimes you're not available. And as we all know, emergencies can crop up in the blink of an eye, and sometimes really important decisions need to be made very quickly. And so, you need to make sure that the stable boarding your horse has your contact information, knows what to do in an emergency if they and who is delegated authority to make these decisions if they can't get in touch with you. If your horse needs to have emergency colic surgery and you're not available, who makes that decision as to whether you're going to proceed or not? And that actually kind of leads to another important piece is your horse insured?
Right.
It do you and what is that insurance and who is your carrier? Because another thing that we see a lot is notice requirements by carriers. They want to be involved, and the insurance contracts require them to receive notice if these big decisions are going to be made, whether a horse is going to be put down, whether they're going to have colic surgery.
Right.
And of course, the insurance company might want to speak to the veterinarian and be involved in that process so that the policy remains in force. And so you want to ensure that that the stable owner or whoever's caring for your horse has that information as well, so that if you, in the event that you're not able to be reached, that stable owner can contact your preferred vet, can contact whoever the decision maker is, and can contact the insurance company to make sure that your horse is being taken care of and your rights are being protected.
Right. And I'm not sure how this question is going to come out, but when you're looking at a contract and you're getting ready to board your horse, well, we're fortunate we get to keep our horses on our own property. But
Oh,
if you're going to board your horse someplace and they lay this contract out in front of you, it's very easy for a consumer to look at all that fine print and go, this is just a basic contract, and sign it. And
mhm.
I can imagine that's probably not the best thing to do. But a lot of that language in there, we just don't understand. Can you actually go to the boarding stable and say, hey, I can't understand this? And how important is that?
Absolutely. And I think that's a really important point and something that I actually, in all of the contracts that I work on, and I think it's very important to stay away from what we like to call legalese, right? It's really important that the contracts are understandable and that the person who's signing has a very clear understanding as to what they're signing on for. And if something isn't clear, then I think it is absolutely appropriate to have that conversation to say, I don't know what this means. Can you explain it? Can we change the language? Can we put it in a way that is more clear? Because when you sign that contract, generally speaking, there's going to be a lot of times there's language above the signature line or somewhere in there that basically says, by signing this, I acknowledge that I've read it and I understand it. And so it is going to be a binding document. So you want to make sure that you have a very clear understanding of what it is that you're signing on for.
Right.
But to that point, one of the things that I try to do in my contracts is to make them very user friendly because not everyone is a lawyer. And in order for these contracts to be enforceable, they have to be understandable. It's if in the event of a dispute, kind of take this indecipherable contract to the court and say, look, Your Honor, they signed this. Well, you know, what it makes it, not to say that the contract would not still be enforceable, but there are defenses that could be raised to say, yes, we had a conversation about what this meant, and my client was duped. They didn't understand this. So
Right.
I think it's very important that all parties have a clear understanding about what is in the contract and which each person's rights are, what their obligations are as well. And one thing that's a lot of times I would advise to be included in a boarding contract is limitations of liability for the stable. And I think it's very important that it is, again, clearly articulated because there's actually 48 of the 50 states have what are called equine activity liability acts. And what those acts do are they're statutes. And what they are is they're statutes that are going to limit the liability for a provider of equine activities. So, in other words, if someone is injured participating in equine activity, it's going to limit the liability of that stable owner or that horse owner. The
Hmm.
purpose of them is to shift the responsibility to the participants. And generally, these statutes are limited to activities that are inherent to the equine activity. But
Right.
again, it is important, I think, for a boarder or a participant to understand what the law says about liability and what they're getting into, because equine activities the law has found are inherently dangerous. I mean, you're riding an animal, you can fall off, you can be bit, you could be kicked. And of course, these aren't things that we expect to happen and don't happen that frequently. But the law has taken a position on them and said you basically has tried to shift the responsibility to that participant. And so, particularly if we're dealing with someone who's not familiar with the equine industry, there's a lot of academy programs and lesson programs where you're trying to introduce the public to this wonderful world of horses.
Right.
And there's not a generalized knowledge about horses and what the risks are. And so that's another very important thing for both sides to have an understanding about what we're getting ourselves into. What are these potential risks? Someone who's never been around horses might not know they could get bit. They might not know they could get kicked. They might really not understand that a horse can spook from something, right? So it's
Right.
important to have these things set out so that everyone knows what their expectations are.
That's fascinating. I didn't realize that there were liability limits in the equine world like that. But
Yes.
it is a very dangerous thing, and a lot of times the rider is part of the problem. So
Hmm.
and if they for like a medical injury and then they want to be covered fully, that might be an unreasonable ask then, because they were may have been part of the cause for the injury.
Absolutely. No, it's always very unfortunate if someone falls and is injured, but in terms of imposing liability on either the stable or the owner of the horse, you're going to have to look at every circumstance with its own, every accident as it happens. But
Right.
there are statutes that come into play. That's when you're going to be looking at those liability releases and the circumstances. Just, the statutes are very broad, and there are exceptions, of course, to every rule. The statutes don't provide exemptions from liability. For example, if there's gross negligence, a reckless disregard for
Right.
someone's well-being. If there's an intentional act, of course, and I have to say I've never come across something, an intentional act, but there it is. Faulty equipment is another area where there might not necessarily be that exemption. If, for example, the stable provider uses a shoddy girth or something along those lines,
Hmm.
the equipment is faulty, then they might be on the hook for liability. So, it's always a good idea for all sides to kind of enter into a relationship with a clear idea of what the risks are, what the responsibilities are, and what the obligations are.
Can you tell us a story about maybe one of your more fascinating cases that you had to deal with and maybe negotiate for a client?
Oh gosh, let's see. One example was actually recently, and this actually goes to our handshake agreement. I don't know if this is fascinating per se, but it is a good example of why these contracts can be so important.
Great.
We represented a stable owner who had a client, and there were a number of sales transactions, a number of horses that were sold. There was a stallion sold for breeding purposes, and and there were written contracts which accompanied some of them. However, there were also side agreements. There were also handshakes. There were also, well, we'll throw in extra breedings. We'll do this. We'll do that. And unfortunately, as you know, the individual who'd been making a lot of purchases ended up being unsatisfied with how the breeding program was going, how the horses were performing, and started wanted to rescind some of these agreements. And so when you kind of when you start into it, you say, okay, well, we have these contracts. It looks great. But then you start getting into discover it and you realize, okay, well, certain representations were made. Oh, yes, well, we did say this about that, but I can't remember. Well, was there one breeding? Was there two breeding? It turned in,
Right.
and that's where, things start to snowball. And so that was actually a case that we went to mediation and we ended up resolving. Some of the horses were taken back. Some of the horses there was actually an exchange of some horses. That's one example of just how handshake agreements or handshake alterations to contracts can get you into hot water.
Right.
Again, it's not in paper. There's different ideas of what's going to happen, and if it's not written down.
I can see that happening very easily. Somebody's unsatisfied, and even though it may not have been in the contract, somebody go, well, listen, let me take care of it by doing this, and then that's not noted anywhere in
Exactly.
in writing, and then later down the road, and like you said, if it's a breeding, well, that's a year later you find out kind of the results of that breeding, or even longer, and whose memory lasts that long?
Exactly. I have another, and then this isn't actually a case that I represented any of the individuals, but it's kind of a funny anecdote. So, a lot of the equine liability statutes require either the boarding facility or the training facility to have signs posted, which would have statutorily prescribed language
Hmm.
indicating that there's limitations of liability. Also, an alternative, some states require it can be in a signed release. In any case, there was a boarding facility that did in fact have the sign up as required, Unfortunately, the goat that wandered around the property had ate the sign or munched the sign. And so unfortunately, there was an accident and there was litigation brought, and the question arose, well, was there compliance with the statute? Was there a sign up? And the answer was like, yes, of course. "Okay, well, let's see it." Well, the goat ate it. And so, as it turns out, in that case, they were aware that the goat ate the sign. Another sign had been brought on and was placed somewhere else. But yeah, having a sign to comply with the statute is all well and good until the goat eats it and it's no longer legible, right? So
It didn't work with my homework and my dog in the sixth grade either. So
exactly, these are the kind of things you can't make this stuff up, right?
that's right. That's right. When you buy or sell a horse, is a bill of sale sufficient, or do you need a contract for that too?
So I typically do also draw up a contract, and there are certain states that have laws that actually talk about what's required when there is a sale of a horse. In Florida, a bill of sale is required, but there is statutory prescribed language that needs to be included in the bill of sale, particularly regarding representations and warranties that were made as to a horse. In other
Hmm.
words, the statute is designed to ensure if I'm a seller and I make a representation about the horse that leads someone to purchase the horse, that if the buyer is going to rely on it, that that's put in writing. And the purpose of that is to avoid unfair and deceptive trade practices. I typically do include, even if it's a short sales contract, include the parties. Make sure that the we have the horse down, right? What is the
Right.
horse and who is the horse that we're selling? What representations are being made? Who bears the risk of loss until the horse is with the new owner? If this is a cross-country transaction,
Oh, yeah.
was there a pre-purchase agreement? Was there a veterinary exam? Are there representations as to the health of the horse? Things of that nature. But bills of sale can be as simple as you like them to be. I would recommend, a good idea to have something in writing to memorialize that transaction.
Right.
Another issue that comes up sometimes, and of course this is more with higher end horses, but commissions. And if we're dealing with agents, who are the agents? Who are they representing? Is a
Hmm.
portion of the sales price going to an agent? And if so, what is that? I get the question asked a lot. Well, how much does a horse cost? And I said, well, I mean, a horse is like a car. You can get one for free, or you can pay $1 million. you know, I mean,
That's
it's just
right.
like anything else, right?
Yeah, yeah. And I do think that one of the important things to keep in mind too, and this may happen on the lower end horses, but to make sure that the person you're buying the horse from has the right to sell that horse or is the owner of the horse, because it might have been passed on to, like you said, somebody got a free horse, they kept it for a while and said, oh no, I want to sell it. The original owner who gave the horse away may say, well, you can't sell my horse.
Absolutely. I'm so glad you brought that up. 'Cause in terms of representations, that is one that I include in every single one of my sales agreement, that the seller is authorized to sell a horse, that they're the rightful owner. I actually had an incident come up a month ago where I had a horse owner who had basically let her horse, I don't want to say it was leased per se, but basically another person was using the horse, paying for it, enjoying the horse.
Hmm.
And the owner wanted to take it back. But the lessor said, "What are you talking about? This is my horse now. You gave it to me."
Right.
And of course, there was nothing in writing. And, we ended up being able to negotiate it. The owner did get the horse back. But again, that's one of those circumstances where there was nothing in writing. It was just handshake agreements, verbal discussions. And to someone standing on the outside, they might say, okay, well, you say you're the owner, but you haven't been paying for the horse. You haven't been riding the horse. Like, you gave the horse to this person. why,
Right.
why, why should why should I believe that you wanted to maintain any type of ownership interest? Things like that. A lot of times you do want to make sure that they're memorialized in some way. So just to protect everyone's rights, so there's a clear understanding.
Yeah. We're going to take a little bit of a break for a brand new sponsor to the Woe podcast. But before we do, I want to tease this question to you. As a recreational trail rider, are there any specific needs that we need to be aware of from in the legal standpoint when we're riding out on the trail and we may be on state property or we may be on public property? So keep that in mind and we'll answer that question right after this. We'd like to welcome a new sponsor to the Woe podcast about horses and horsemanship, Echo Gold Saddle Pads. Your saddle pad is the connection between you, your saddle, and your horse, and impacts the quality of your ride. Echo Gold Western saddle pads are 100% North American made with your horse's comfort in mind. Whether you're executing a high-impact maneuver or navigating tough terrain, Echo Gold's complete line of Western saddle pads can help solve saddle fit issues, reduce a horse's back discomfort, and allow free shoulder movement for peak performance. If you experience saddle slipping or ride a barrel-bodied horse, the Western Secure Pad offers a contoured shape and non-slip fabric that keeps the pad comfortably in place. If you ride a sensitive-backed horse, the Calmatech Western Saddle Pad gives maximum comfort with medical-grade fleece to prevent rubbing and impact. Both pads offer 2 vents on the spine, feature a layer of 3D airflow spacer to improve sweat evaporation, they're shimmable for a perfect fit, and the best part of all, they come in a wide array of color choices. Most importantly, they're machine washable, which prevents the spread of skin conditions and keeps your pad looking great ride after ride. Choose your perfect Echo Gold Western pad at select retailers and at echogold.ca. Echo Gold Saddle Pads, designed to put the comfort of your horse first. Okay, and we're back. And so, Johanna, is there anything for the average trail rider that we need to do to protect ourselves when we're out on the trail?
I think that you always want to make sure that you are complying with any local and state ordinance or governance, right? You want to ensure that you are aware of signage in terms of trespassing, private property, things of that nature. In terms of liability, again, if you're just going onto a trail and they don't have any type of form, there's usually no one standing there asking you to sign a release or anything along those lines.
Right.
I would say the most important thing for you to be aware of is just making sure that you're staying on the trail, not veering off and not onto someone else's property. I think another thing you want to try to ensure is that, when you come across others on the trail, you're cognizant of yourself, your space, their space, and your surroundings. If there's other horses on the trail that might, have a red ribbon or, have a propensity, if you're on a horse that has a propensity to kick or a propensity to bite, you want to make sure that if you come across others on the trail, that you're just being cognizant, that you give any notice that's required to make sure that you're protecting your space and you're helping others make sure that they maintain a safe space as well.
Right. And make sure that can't claim that gate was just happened to be open so you went through it perhaps.
Exactly. Gates don't open themselves usually.
That's a good point. That probably the dangerous thing about trail riding is the liability that because you're on somebody else's property, so any damage that you cause to that property, or if you have an accident on their property, you can't then claim they're liable because they provided that space for you to ride your horse, I suppose.
That's true. I think that there are potential exceptions if there's some type of a very dangerous condition that the property owner did know about but did not disclose. It's some type of a latent condition. There might be some type of a vehicle for recovery, but generally speaking, you're right. If you're injured on that person's property just because through the nature of equine activity, maybe, there's a squirrel or, an
Right.
animal runs, there's a your horse spooks, you fall off. That's generally not going to be something you're going to be able to recover from. And so, of course, for that reason, you want to make sure that you're taking care of yourself. You're making sure that your equipment is all in good order, using appropriate safety precautions, whether it be helmets or otherwise, to make sure that you're protecting yourself.
We would ride out in a farmer's property, and he was very pleasant about letting us ride through his property. And there, he kept about 30 hives of bees that we had to ride past to get into some open area where we enjoyed riding. We kept our mouth shut and our collars buttoned as we rode by these bees, but we couldn't then come back to him and say, well, what were these bees doing on this property? Because we were enjoying his land. So,
Exactly, exactly. There is that tension there, but that the bees, that would make me a little nervous. But I'm glad
yeah,
you emerged unscathed.
we did. So I think the whole concept about the law and horses is that you can do a lot to create peace of mind if you do a little planning ahead.
I think so, absolutely. A little planning, not only in the equine sense, but in and I think all of our aspects of our life, a little planning can go a long way.
Right. And even though everyone may have good intentions, there's no harm in, or even a reason to take offense if you write those intentions down and then have each party sign it.
Certainly not. And I think that there sometimes is a hesitation to put things in writing because you don't want to offend the other person. You
Right.
don't want to seem overbearing. But I think that at the end of the day, it really behooves both parties to have those things in writing. I had dealt with a very sad incident, and it involved a lease, and there was an individual who had leased their horse out to another. There was a year-long lease, and the person leasing the horse was able to show and so on and so forth. And
Hmm.
the lease didn't automatically renew, and at the lease terminated. And then there was someone else who was going to maybe take over, and they'd started using the horse and hadn't signed any papers yet. And unfortunately, the horse, it was a freak accident, one of those things that happens.
Oh,
It was just, it was the leg shattered. He had to be put
oh,
down. It was just terrible. And everyone's grieving, and I hate to bring things back to money, but the original lease had a provision where the person who was leasing was going to maintain insurance on the horse for vet bills and mortality.
right.
And there was nothing, but that lease had expired, and the new folks hadn't signed anything yet, so there was no coverage for the horse. And that was one of those, just one example of how best of intentions can make a really devastating event
Right.
even worse.
Yeah.
And so, you do want to make sure that you memorialize things and you make sure that you have a clear understanding of what you're getting yourself into and what the expectations are. Because unfortunately, when you haven't done that, at some point there's very little. Sometimes lawyers can't help you.
Yeah.
What you say, sometimes you have to say, "I'm sorry, you might be out of luck here."
Yeah. If you own a horse and you're in the horse world, you know that there's not only a lot of work, but there is a lot of money involved too. So you want to make sure that you can protect yourself as many different ways as possible. Yeah, boy, I feel bad for that person who there was kind of just a gap in coverage almost
Hmm.
there.
Yeah, yeah, it's a very sad scenario. But not to bring things down.
Right, exactly. Well, this has really been fascinating, Joanna. I really appreciate you coming on the show. Is there anything else that you wanted to bring up?
I think I've spoken about really everything that I'd wanted to talk about, just to kind of emphasize, while handshake agreements I think they're great, they're traditional, but they don't offer the protection that a written agreement does. So I would encourage all of your listeners, when engaging in transactions involving horses, to memorialize them in some way. It doesn't have to be very complicated. It can be very straightforward, layman terms. It doesn't have to be in legalese, but just writing down each party's expectations, I think is really helpful. And I would also encourage your listeners, if you own a boarding facility or you're a trainer, to go ahead and check with your state's equine liability laws to ensure that you are complying with any obligations that it might impose, and that you're just aware of what the risks are as a person who's offering board or training. And similarly, if you're someone who has horses and you're boarding them somewhere, you want to know what your rights are as well. So it's always a good idea to have a sense of those laws.
I think that's really good advice, and and even if you're making an arrangement between a friend, I think it's good just to put something down on even if it's a napkin or a feed bag that you write down, but you write down just what your expectations are and what they can expect, and because like you said, I think most disagreements really can start from that handshake agreement. Well, I'm going to do this and you do that, and then things can deteriorate.
Absolutely.
So if people would like to contact you or learn more about your law firm, where shall we send them?
So, anyone who would like to learn more, I would encourage them to visit our website. It's sheeheandassociates.com, and I'll spell that out because that is a mouthful.
Okay.
It's SheeheAssociates.com. We also have a Facebook page, and or you can visit my LinkedIn profile as well. And again, my name is Johanna Sheehe.
Awesome. And I'll put all those links and a couple of photos in the episode page at wopodcast.com. Well, this has been a lot more fun than I thought it was going to be, Joanna. I got to tell you that.
Well, thank you. I think us lawyers get a bad rap sometimes.
Well, law and geometry are probably my two weaknesses. So, but you made this very, very palatable. I really appreciate it.
Oh, well, thank you. I appreciate that. It was really a pleasure. I appreciate you letting me come on.
Great. Thank you, Joanna. Have a great day.
You too. Bye-bye.
That will do it for this episode. I must say that when I was approached to do an episode with a lawyer, I balked. Somehow, I equated it with reading the license agreement when you install software on your computer. But because I find their world so confusing, I wanted to learn more, and I'm glad I did. Joanna is very easy to talk to, and the information she provides can head off a world of problems you don't want to deal with. Thanks, Joanna, for sharing your knowledge. If you have questions for Johanna Sheehe, I'll have her web address, contact info, and other links in the description at wopodcast.com. Spring is upon us. I think COVID is behind us. Your horses are out there ready for you to enjoy. I hope you get after it. As always, if you'd like to share a story or experience about your horse or suggest a guest, let's hear it. Send an email to john@wopodcast.com or connect with me on Facebook, Twitter, or Instagram under the name Whoa Podcast. I love hearing from you. Thanks again for listening and sharing the podcast with your friends and riding buddies. Until next time, for Renee, this is John Hare saying, go have some fun with your horses. Bye-bye, everybody.